It happened at 9:06 a.m. on a Monday in February in the third-floor hallway of the Cuyahoga County Courthouse in Cleveland, Ohio, while the fluorescent light above Gate 7 was still doing the low, unsteady flicker that a maintenance request filed on January 18th had promised to fix within 10 business days. The man had been sitting on the wooden bench outside courtroom 318 for 22 minutes. He was wearing a dark navy suit. He was holding a manila folder on his lap with both hands. He was not making noise. He was not in anyone's way. He was doing the thing that people do in courthouse hallways on Monday mornings. He was waiting. Officer Kevin Price came through the stairwell door at 9:04 a.m. and looked at him and made a decision in under 3 seconds. What followed, documented in full by the security camera mounted on the east wall of that hallway, a camera whose footage was uploaded automatically to a backup server at 9:00 a.m. Every morning, meaning everything from 9:04 onward was already preserved before Officer Price had any reason to consider it, lasted 4 minutes and 11 seconds. There was the demand to see identification from a seated man who had committed no observable offense. There was the order to stand, then to put the folder down, then to put his hands where they could be seen, as though the man's hands, folded over a manila folder in a courthouse hallway on a Monday morning, had communicated something that required an immediate tactical response. There was the escalating language. There was the moment at 9:08 a.m., documented in time-stamped footage that would eventually be reviewed by 7 separate individuals, including a federal civil rights investigator from the Department of Justice's Cleveland field office, when Officer Kevin Price leaned forward and spat. The man did not move. He did not wipe his face. He stood with his hands visible and his eyes forward, and he waited, with the particular stillness of someone who has decided, with complete clarity, that the only thing that matters right now is reaching the other side of this moment without giving anyone anything else to use. 2 clerks passed through the hallway during those 4 minutes and 11 seconds. One looked at the floor. The other one looked at the floor too. There was one other person present, a custodial worker named Ade Mensah, 61 years old, who had been mopping the far end of that hallway since 8:40 a.m., and who did not look at the floor. Ade had been working in that building for 19 years. He had seen enough in courthouse hallways to develop a precise instinct for the difference between things that would resolve themselves and things that someone needed to remember. He set his mop against the wall. He stood still. He memorized what he was watching the way his grandmother in Accra had taught him to memorize the things that mattered. Go still, and pay attention with your whole body. As though the scene in front of you were something you would one day be asked to describe under oath. He did not know then how accurate that instinct would prove to be. The man's name was Chukwuemeka Adaeze Okafor. He was 54 years old, 177 pounds, and he had been appointed to the 8th District Court of Appeals for the state of Ohio 14 months ago. He had spent that morning, as he spent every Monday morning, doing the thing he had been doing for 26 years, showing up to a courthouse. Showing up exactly on time, exactly prepared, exactly dressed, not because anyone was watching, but because that was the agreement he had made with the work, and he did not renegotiate agreements. He was born in Cleveland in 1970 to Bartholomew and Grace Okafor, who had arrived from Enugu, Nigeria in 1967 with $180, a single airline ticket stub they kept inside a Bible, and a shared conviction that the law was the one language that could be learned completely and spoken in this country without an accent. Bartholomew worked as a hospital orderly at St. Vincent Charity Medical Center on East 22nd Street for 18 years, while putting himself through night school at Cleveland State University. Grace taught 4th grade at Patrick Henry Elementary School on East 1 and 40th Street for 31 years. They had attended every one of Emeka's hearings across 26 years, not one missed. Not even after Bartholomew's knees gave out and the drive to the courthouse took 40 minutes and required 3 stops. They had both died before the appellate appointment came through. He carried this the way you carry something too heavy for a single pocket, distributed carefully across every part of yourself so that no one point shows the full strain. He was wearing a dark navy suit he had bought off the rack at Dillard's on Euclid Avenue in 2019 for $340 during a President's Day sale. It was not the finest suit he owned. In the closet at his home on Fairmount Boulevard in Cleveland Heights, still in the dry cleaning bag, still with the fold across the shoulder that the cleaners always put in, was a charcoal wool blend his law partner Marcus had given him the week the appellate appointment was announced. He was saving that suit for the presiding judge ceremony the following April. For a Monday in February, the navy suit was correct. His mother had told him more than once that dignity was not about what things cost. It was about the care you gave them. The navy suit was pressed. He had pressed it himself on Sunday evening, methodically and without haste, while the news played in the background. The way she had shown him, collar first, then the yoke, then down each sleeve. He carried the manila folder in both hands. Inside it were three things: the scheduling order for the 9:30 a.m. matter, his handwritten notes on the controlling precedent from a 2019 Ohio Supreme Court decision, and a photograph of his parents taken outside the Cuyahoga County Courthouse in 1982. The day Bartholomew received his paralegal certification after 4 years of night school. His father was grinning in the photograph. His mother was not. She was looking at the camera with the expression Emeka had spent 42 years learning to read correctly. Not severity, not pride exactly, but the specific look of a woman who understood the weight of what she was standing in front of and was not going to diminish it by smiling. He had been carrying that photograph in various folders and portfolios for 22 years. He took the stairs on Monday mornings because the north elevator was slow, and the south one, according to a colleague who used it daily, smelled like a room no one had opened since 1987. He came through the third-floor stairwell door at 9:02 a.m. He found the bench outside courtroom 318. He sat down. He opened the folder and reviewed his notes. He was 177 pages into the record of the case and had 3 questions he intended to put to counsel. He had been sitting quietly for 22 minutes when the stairwell door opened again and Officer Kevin Price came through it. Officer Kevin Price had been with the Cuyahoga County Courthouse Security Division for 11 years. He was 38 years old, 228 pounds, and wore a name tag above his badge with a small crack in the laminate along the left edge from an incident in the break room in 2020 that he declined to explain in detail. He had 11 years of service, and he had, in those 11 years, received 14 civilian complaints. 3 had resulted in formal discipline. The other 11 had been filed, reviewed, and closed with no action, a sequence that is not unusual in large institutional settings, and that is precisely the problem with large institutional settings. He carried himself through hallways with the particular authority of a man who had never, in 11 years, encountered a consequence significant enough to cause him to alter his behavior, and who had therefore concluded that his behavior required no alteration. He ran no prior check on the man on the bench before he spoke. He saw the bench, he saw the man, he made his decision in under 3 seconds, and he began. He demanded identification. The man produced it without speaking. A black leather billfold opened to a state-issued driver's license, held out with one hand. Price looked at the license and handed it back. He told the man to stand. The man stood. He told the man to put the folder down. The man placed it carefully on the bench beside him. He told him to put his hands where they could be seen. The man put his hands at his sides, palms forward, the way you hold your hands when you have decided that your hands are going to demonstrate something about you that no other part of your body is currently able to. Price told him that this area was restricted to court personnel and attorneys. The man said, quietly and without raising his voice, that he had a scheduled matter in courtroom 318 at 9:30 a.m. Price said he did not see anyone on the docket who looked like him. The man did not respond to that statement. He asked once whether he was being detained or whether he was free to go. Price told him if he said that one more time, he would find out what being detained felt like. Then came the moment at 9:08 a.m. And then the man stood with his hands at his sides and waited. And Ade Mensah stood at the far end of the hallway with his mop against the wall and memorized everything he was seeing. And the two clerks who had passed through found reasons to look at the floor, and the fluorescent light above Gate 7 flickered and did not go out. Price told the man to leave the building. He said it with the finality of someone who is accustomed to sentences ending conversations. The man picked up the manila folder from the bench. He straightened the front of his jacket with one hand, slowly, collar to lapel, the way his mother had taught him to adjust his clothing, not for vanity, but for declaration. Then a door opened at the end of the hallway. A clerk in a gray blazer with a lanyard reading court staff stepped out and looked toward the bench and said, "Judge Okafor? If this story is already in a place in your body that you recognize, stay with me. Because what happens in the next 60 seconds and in the 36 hours after it is something Officer Kevin Price was entirely unprepared for." Emeka picked up the folder. He walked toward the clerk. He did not look back at Price, not once, not with any part of his body, because he had decided before he reached the third-floor landing that morning that the hallway was not the thing that required his full attention. The courtroom was. Behind him, Officer Kevin Price did not move. He stood in the hallway with his hands at his sides, and the kind of understanding moved across his face that arrives not gradually, but in a single wave, the way cold water arrives when someone has been standing a long time in direct sun. At 9:30 a.m., the bailiff of courtroom 318, a man named Gerald Otis, who had served that courtroom for 11 years and who possessed a particular gift for calibrating his voice to exactly the weight of the moment, walked to the front of the gallery and addressed the room. The gallery held 14 attorneys, 2 court reporters, a Case Western law student present for a clinic requirement, and, in the back row on the left side, Officer Kevin Price, who had followed the clerk's path down the hallway and entered the gallery because he had a complaint to file at the clerk's window after the morning session, and had decided to wait where it was warm. Gerald Otis said, "All rise for the Honorable Chukwuemeka A. Okafor, Judge of the 8th District Court of Appeals." The room rose. Judge Okafor came through the door behind the bench in his robe, set the manila folder on the surface in front of him, looked out at the gallery the way appellate judges look at rooms, with the thoroughness of someone who has learned over decades that the most important information is rarely at the center of things, and sat down. Officer Kevin Price did not sit down with the rest of the gallery. He stood at the back of courtroom 318 for 7 seconds by the clock on the east wall. Then he sat very carefully, the way a person sits when their legs have stopped receiving clear instructions. He remained in the gallery through the full morning session, which ended at 12:14 p.m. He did not file a complaint. He did not leave his seat except to stand at the appropriate moments. He turned twice when the back door of the gallery opened, and both times he appeared to be determining whether it was possible to leave without being seen from the bench. It was not possible to leave without being seen from the bench. Judge Okafor had noticed him in the third row from the back before the first matter was called. He said nothing, called the docket, and conducted the morning's proceedings with the same thorough and unhurried attention he brought to every session. He was a judge. The courtroom was his. The work of the morning was the work of the morning, and that work belonged to the people who had come to that courtroom with cases that needed deciding. And he was not going to give any portion of that work to anything else. But he saw Price. He saw him the way a man sees something from the corner of his eye, and does not turn his head, because turning his head would give the thing a significance it had not yet earned. It was Ade Mensah who connected the two halves of the morning. He had finished his hallway shift at 10:00 a.m., changed out of his work clothes in the basement locker room, and gone up to the third-floor gallery to catch the tail end of the session the way he sometimes did on quiet Mondays. The way someone who has worked in a building for 19 years develops a relationship with its rooms and the things that happen inside them. He recognized Price at the back of the gallery. He recognized the judge on the bench. He sat down in the second-to-last row and folded his hands in his lap and understood, with the complete calm of someone who has been paying attention for a very long time, exactly what had happened in the hallway at 9:06 a.m., and exactly what it meant for the man who had done it. That evening, Ade went home to his apartment on Addison Road in East Cleveland and wrote it down. He had a spiral-bound notebook in the kitchen drawer, the cover worn where he gripped it. He had been keeping notebooks like this since 1997, when a man he worked with at a machine shop had told him that the only thing that protects what you witnessed was writing it down while it was still alive in you. He wrote 6 pages that evening. He included the time, 9:06 a.m., the exact language Officer Price had used, and the moment at 9:08 a.m. He described the position of the 2 clerks. He noted the direction they looked. He described the state of the fluorescent light above Gate 7. And he underlined one sentence. He did not wipe his face. He stood with his hands where he had been told to put them, and he waited. The following morning, before his 8 a.m. shift, he submitted written copies of his account to 3 offices: the Cuyahoga County Courthouse Security Administration, the Cleveland Division of Police Internal Affairs Unit, and the Administrative Office of the 8th District Court of Appeals. The last one he delivered in person, in a sealed envelope, to a clerk named Patricia at the second-floor reception desk, because Ade Mensah did not trust the mail with things that needed to arrive. Judge Okafor received the envelope at 2:17 p.m. on Tuesday. He read it once. He set it down. He sat with it for 11 minutes, in the particular way he sat with difficult things, not rushing toward a response, not pushing the feeling away, but holding it the way his father had held the hard things, with both hands and without flinching. He did not call anyone in the media. He did not call a press conference. He called his clerk and added one item to Thursday's calendar. Then he called the facilities office and left a message for Ade Mensah. I received your letter. I want to thank you in person, if you're willing. Ade called back in 14 minutes. They met on Thursday morning at 8:15 a.m. in a conference room on the second floor. Ade brought the original account in a clear plastic sleeve. Judge Okafor brought 2 cups of coffee from the break room machine down the hall. The machine that everyone in the building agreed produced coffee that barely qualified as the concept. He was not a man who needed things to be perfect. He needed them to be present. He thanked Ade. Then he asked, "Why did you stay?" Ade thought about it. Then he said, "Because nobody else was going to." Judge Okafor set his coffee cup down. He looked at Ade for a moment without speaking. Then he said, "That is the correct answer." Officer Kevin Price was placed on administrative leave pending investigation on Friday of that week. The investigation, initiated jointly by the Cleveland Division of Police and the Cuyahoga County Courthouse Security Administration, was remarkable for 2 structural facts. First, the east wall security camera, footage backed up automatically each morning at 9:00 a.m., already secured before anyone thought to consider it, had captured the full 4 minutes and 11 seconds in uninterrupted, time-stamped detail. Second, the scope of the investigation was formally expanded within 48 hours of its opening to include a review of all 14 prior complaints against Officer Price across his 11-year service record. The 3 that had resulted in formal discipline were examined. So were the 11 that had resulted in closed files and no further action. The Courthouse Security Administration announced the following month that it was convening an independent review panel, chaired by a retired federal magistrate, to examine the institution's complaint intake and resolution procedures. The panel's mandate included a specific inquiry into how complaints could be filed, categorized, and closed without consequence across more than a decade of documented pattern behavior. The panel's first working session was scheduled to be held on the 3rd floor of the courthouse itself, down the hall from courtroom 318, under the flickering light above Gate 7, which had by then finally been repaired. The civil matter was settled by the city of Cleveland for $215,000 within 60 days. Judge Okafor directed the full amount to the Glenville Neighborhood Legal Aid Clinic on the East Side, which provided free civil legal services to residents of the neighborhood where he had grown up, and where his mother had taught fourth grade for 31 years. The clinic's director said she had not been surprised. She said that was exactly what he would do with money he had not asked for and did not need to keep. His presiding judge ceremony took place the following April as scheduled. He wore the charcoal wool suit from the dry cleaning bag, collar pressed flat, fold across the shoulder eased out by the iron that morning. In his remarks, which ran 11 sentences, the 9th sentence was this: "The courthouse belongs most to the people who need it most, which is rarely the people who feel most comfortable inside it, and the obligation of everyone who works in this building, on the bench, at the window, in the hallway with the mop, is to make certain that every person who walks through these doors on a Monday morning can do so without being asked to prove that they belong here." Aide Mensah was in the gallery. 3rd row. He had pressed his clothes that morning. He brought the spiral notebook in his inside jacket pocket the way he brought it everywhere. He sat and he listened, and when the ceremony ended, he stood with the room and clapped without hurry, the way you clap for something that is not a surprise, but that needed, nevertheless, to be seen. There is something that does not get said clearly enough about people who carry their dignity like a second skeleton, something load-bearing and invisible beneath the surface that does not bend regardless of what pressure is applied to the outside. Emeka Okafor had built that structure over 54 years, from material given to him by a father who mopped hospital floors and studied law at night, and a mother who taught children on East 140th Street for 3 decades, and looked at courthouses with the expression of someone who understood what they were actually for. You do not assemble that kind of foundation in an afternoon. You inherit it, and you build on it, and you carry it through Monday morning hallways, and you do not flinch, and you do not wipe your face, and you wait. What Officer Kevin Price saw on that bench was a man in a Navy suit. He looked at the surface and decided he understood everything. That is the oldest and most expensive mistake a person can make, not merely in the financial sense, though $215. 000 is a meaningful number, but in the durable institutional sense, the kind of cost that changes how a building operates from the inside, that opens a review panel, that rewrites the procedures, that puts an independent magistrate in a room on the 3rd floor, looking at 11 closed files and asking the one question that should have been asked years ago. You cannot read 30 years of legal work from a bench in a hallway. You cannot look at a Navy suit and determine what is inside it. You cannot know what a person carries in a manila folder held with both hands. And you cannot unknow the 7 seconds at the back of a courtroom when you are standing and the room is rising, and the bailiff says the name of the man you told to leave the building 40 minutes ago, and the understanding arrives all at once, cold and complete, and your legs stop working on the instructions you were giving them. The people who sit in judgment of who belongs in a room are often standing in a room they have never fully understood, and at the far end of the hallway, a man with a mop against the wall is paying careful, patient, 19-year attention. And he has a notebook, and he will write it down tonight while it is still alive inside him. Leave your answer in the comments if you had been Ade, not the judge, not the officer, just the person with the mop at the end of the hallway. What would you have done? Most people say they would stay. Most people are not actually in the hallway. I want to know which one you are. Subscribe for more stories about hidden strength, quiet power, and the people the world overlooks until they change everything. I'll see you in the next one.